I'm really pleased to join all of you here today to discuss estate planning. I give you a lot of credit for taking an hour and a half out of your day to learn about all of these issues. So once again, my name is Kendra Bowen. I'm an estate planning attorney with HERA. I'm joined here today with Irene Zhu. She's also an estate planning attorney with HERA, and Susan Ye, who is our most recent hire. Our department is growing because there's a big need for estate planning. Just a bit of background about why HERA, the Housing and Economic Rights Advocates, decided to start an estate planning department. HERA does a lot of work helping homeowners save their homes, obtain loan modifications, prevent foreclosures, but they were discovering that if a client became incapacitated, they no longer had the authority perhaps to help the client. They didn't have anyone to stand in the shoes of that incapacitated client. And in a similar vein, when a client passed away, oftentimes, let's say a child was the caregiver for a parent in a home, and a home was the means of where that child was living. When that parent passed away, there was not a mechanism to make sure that that home would perhaps go to that child. Families were losing homes. So hence, this is why we started estate planning here. And I understand that many of you are parents, so that gives you an additional reason to do your estate planning. All right, so today we're going to go through two different types of scenarios, essentially two different types of estate planning documents, some of which cover what happens if we became incapacitated, even temporarily, from a bike accident, car accident, something like that. And then what happens when we pass away one day. And there are two different groups of documents that cover all of this. So Irene, if you would start sharing the screen, that would be great. All right, so next slide, we will go through the what, who, when, why, and where of estate planning today. And next slide. So first of all, we're going to go through a couple of misconceptions about estate planning. Many people think, they don't own anything. They're going to be a renter. They don't anticipate owning a home one day, so they really don't need estate planning. But keep in mind that everyone needs some type of estate planning because, as I mentioned, you have yourself. You have situations that may take place if you're incapacitated and you need someone to advocate for you and represent you. So there are certain estate planning documents that cover incapacitation. So in essence, everyone needs some type of estate planning. Next slide. People understand that California does have a mechanism to distribute property at death. And that mechanism is there in case people have not indicated in writing through properly notarized and witnessed documents what they want to have happen with their assets if they should pass away. So California does have a mechanism, but if you take the time when you have capacity and you're feeling good to evidence in writing what you want to have happen when you pass away with your assets, who you would choose as a guardian for your children, that will 99% of the time prevail. So if you take the time now while you're in a good place and feeling good to indicate your desires in properly notarized and witnessed documents, that will trump the mechanism that California has in place for that transition in life. And then many people believe that since at some point they created a will, that this avoids probate in California. And we'll delve into probate a bit more as we go through our time together. But probate kicks in if you own over $166,250 worth of assets. If you do not have a will and you are distributing that amount or exceeding that amount in assets, your family would go through probate. If you have a will is even subject to probate if it is dealing with assets that exceed that threshold amount. So for some people, a will is appropriate if they have under $166,250. But for those of you who are perhaps homeowners, you clearly own an asset that is worth more than that amount. So a will would not protect your loved ones from going through the probate process. Okay, next slide. And a common misconception is that a parent has 3 children, they understand what is to happen one day, who is to take care of mom, and how property will be distributed, who would, take the kids. Well, when people pass away, you tend to see the worst characteristics come out. So you really don't want to rely upon verbal guarantees from kids that they will take care of things in the manner that you wish. It frankly helps to keep the peace in a family if you take the time when you're feeling good to indicate your intentions about who is going to take over for you, how assets will be distributed. It just makes it much easier for the next tier of people. And next slide. So estate planning is not only what happens when we pass away, what happens to our property at that point, but it involves indicating and nominating an agent to take care of our property and assets while we're alive, but let's say incapacitated, and to handle healthcare issues while we're alive but incapacitated. If doctors could not effectively communicate with us, we would want someone in place who would have authority to communicate with doctors and advocate for us in that medical setting. Next slide. So with those 2 different types of issues and 2 different groups of documents, in the blue, we have documents that are important while we're alive. So a durable power of attorney would nominate someone to take care of financial tasks, let's say filing a tax extension, representing us in a lawsuit. We have a revocable amendable trust where we would nominate a successor trustee to take care of trust assets. Keep in mind that trusts are amendable, revocable. When you create your trust, you are completely in charge of your assets. You can change your intentions as expressed in that trust at any time. And then we have the last document in blue, our advanced healthcare directive. And of course, this is only relevant when we're alive, but it indicates our intentions about specific medical scenarios and who we trust to make sure that those intentions are followed. Then the documents that we have in the yellow are documents that become important when people pass away. So we have a trust, which was previously amendable and revocable, which when you pass away, it obviously cannot be changed by anyone. And then we also have a last will and testament. Both of these instruments and writings will distribute property at death and typically nominate guardians for children under the age of 18. Next slide. So we're going to dive into the 2 groups of issues and documents here a little bit more in depth. We're going to dive into incapacity during lifetime, how we nominate someone to manage our assets and also make healthcare decisions. And please keep in mind, these can be 2 different people that you nominate for these different documents, which require different skill sets. And then we also have our post-death planning. It's tough to think about, but we need to indicate choices about guardians and where we want assets to go and when assets would eventually be distributed to children. Next slide. So first of all, we're going to discuss the bigger topic here, what happens when people pass away. And so as I mentioned earlier, what we want to do in California is avoid probate. And probate is expensive. It typically requires hiring someone like me, Susan, Irene, to help an executor or help a personal representative to go through the probate process. Keep in mind that the probate court looks at the gross value of the estate when determining whether or not an estate is going to go through probate. So the threshold amount we have here is $166,250 gross value of an estate. So if someone owns a home worth $500,000 and they have a loan against it of $400,000, even though the equity there is only $100,000, unfortunately, if that person passed away, their loved ones and personal representative would need to go through the probate process, which would definitely eat away at the equity there to be ultimately distributed to family members. So in determining whether or not you would need a trust or a will, an attorney will evaluate what you have and what you anticipate acquiring through the years and help you make a determination if a will is enough or if you really need to go ahead and do a trust and prepare a trust and put your home or other assets into the trust. Next. Okay, so we want to avoid probate, right? Well, we have a couple different mechanisms to avoid probate. So of course we can prepare a trust. It's a revocable trust, an amendable trust. The trust is you. So you are accountable to no one. The assets are still yours. You just hold title a little bit differently on those assets. So for instance, if you own real property and you create a trust and put your home into the trust, instead of Sam Smith owning the home, it'll be Sam Smith, trustee of the Sam Smith Revocable Trust, which will own the home. There's no property tax reassessment. It's amendable. So if you change your mind as to a choice of guardian or how you would like assets distributed in 10 years, you can always amend your trust and change your intentions as long as you have proper legal capacity. So it's meant to grow with you, with families as you go through the years and change your intentions or acquire new assets. You would create a trust and then put your assets into it. If, let's say, you sold property that was currently in a trust, you would sell it on behalf of the trust and then purchase a new property in the name of the trust. So once again, it's meant to grow with you as you go through the years and hopefully obtain new assets. In California, we also have a transfer on death deed. This is a mechanism that you can use to distribute property if you should pass away. It's a simple 2-page deed where you're going to indicate beneficiaries on the deed. We'll discuss it a bit more in depth later, but there are limitations by using this tool, so it's not appropriate for everyone. We also have the option to indicate beneficiaries on various accounts. So it's called a POD, pay on death designee. It's basically putting a beneficiary down and stating that if you passed away, that individual would bring a death certificate to that institution, and that institution would distribute assets to the beneficiary or the POD designee. That's a way to avoid probate, and it's a fairly simple way. Sometimes it doesn't work with minor kids because you wouldn't really want minor kids typically to acquire assets. 21 would probably be the earliest that you would want a child to acquire an asset outright. We also can hold property as joint tenants with someone. So oftentimes couples hold property as joint tenants or community property. This works as far as the death of the first person goes. So if, let's say, a couple holds title to accounts or property as joint tenants and one of them passes away, the other person will automatically own 100% of that property. But at that point, if that last person passed away, there would be a big probate. So we don't want to rely too heavily on this. It works as far as the death of the first person, but once again, the last person standing would need to dive in and prepare estate planning documents to prevent a probate when that remaining person passed away. And in a similar vein, if we own property, once again, as joint tenants, if we're registered domestic partners or as community property, that's a similar way to hold it as the joint tenancy was, and it does work as to the death of one person. And then with our retirement accounts or any life insurance proceeds, we can put a beneficiary on those instruments. So this is a good time while you're thinking about this to revisit those beneficiary designations on those accounts and make sure that you not only have a first designee or beneficiary. You might have a parent down, someone who's older than you, but you want to make sure to place a contingent beneficiary down on that asset, perhaps someone younger, so that that first beneficiary predeceased you and you didn't get around to changing the beneficiary there, and thereafter you passed away, you would want to make sure to avoid probate and have that asset easily go to the second named beneficiary there. Okay, so we have different tools to avoid probate. What's appropriate for retirement accounts is to place beneficiaries on them. With life insurance, it's important to name beneficiaries there as well. If we own real property, typically owning that property in a revocable trust would make the most sense. Next slide. All right, so to discuss the trust a bit more. In a revocable trust, once again, as I said earlier, you are everything. You own everything. You're the beneficiary of it. You're accountable to no one. You could sell it, spend it, go on trips, live a lavish life. And once again, you're accountable to no one other than yourself. So a trust is going to refer to you as the settlor, grantor, trustor, trustee, beneficiary. You are everything. It will indicate a successor trustee to take over if you are incapacitated or when you pass away one day. And when you pass away one day, that successor trustee would make a distribution to your beneficiaries. But until that time, everything is yours. With the revocable trust, we do have a will. It's typically a pour-over will. And what happens there is the will kind of grabs things that perhaps were not diligently placed in the trust and funnels them into the trust so that they are distributed to your people according to the terms expressed in the trust. And a trust can be called a trust agreement, a declaration of trust. It really doesn't matter what it's called as long as it is properly funded. In a trust, you're typically going to name your family members. If you're married, if you're single, you're going to state the legal names of your children. If for some reason you are disinheriting a child, you're going to indicate that you have that child, but that you specifically disinherit that child because we want to make your intentions very clear. The trustee of your trust can be compensated, but doesn't have to be. So you get to decide that. The successor trustee will also keep track of what he or she is doing down the road, but you as a primary trustee do not need to keep track of anything. You're not accountable to that next tier of people. And a good trust typically has a spendthrift clause, which ensures that beneficiaries can't claim an interest in your property until you pass away and until a distribution is made to them. And it typically has a no contest clause in there, which states that if any of the beneficiaries say that you promised to give them more than what's stated and causes a ruckus with your successor trustee, they won't get anything. So once again, it's meant to help keep the peace and help things rather seamlessly, help assets seamlessly be distributed to the next tier of people. Next slide. The difference when someone passes away between probate and a will and doing a trust administration is pretty big, pretty significant. So with the trust, there is no probate as long as assets have been placed in the trust. A will is subject to probate if it exceeds $166,250 with the assets that are distributed under the will. A will is public. When someone passes away, a will is filed. A trust is not filed. In a trust, there are no statutorily guaranteed fees to the successor trustee or to his or her attorney if that successor trustee chooses to hire an attorney to help. With a will, there is statutory compensation, and the compensation is quite high and can take a chunk of money out of the estate to be distributed. With a will, the executor has to do a lot of administrative tasks with the probate court, and with the trust, the successor trustee does not. Assets in a trust are not subject to estate recovery, but assets in a will would be subject to estate recovery if there was a medical claim or something like that. And a will, once again, if it deals with assets that exceed $166,250, takes longer to probate. There's more hoops for the executor to jump through, so it just costs more money and takes longer. With a trust, the administration of trust typically is shorter and it is less expensive to do. Okay. All right, next slide. So keep in mind, for those of you who perhaps are not homeowners, don't anticipate purchasing a home, can just put beneficiaries down on retirement accounts, beneficiaries down on a life insurance policy, put beneficiaries down on a bank account perhaps. You possibly can get by with just doing a will to distribute assets at your death, as long as it's under that threshold amount. And of course, if you decide to just do a will, you would need a power of attorney and healthcare document as well to deal with incapacitation. If you ever exceed that threshold amount, there would be a probate. So hopefully you would go back to your estate planning attorney and have a trust done instead if you exceeded that threshold amount, because you would definitely want to avoid probate down the road. Next slide. All right, so probate, it's expensive and takes a long time because you're paying the court and your attorney, frankly, to oversee the process for transferring an estate to beneficiaries. So the court validates the will. The court is going to appoint a personal representative. That person needs to make an appearance. That person needs to file an inventory of assets. Okay, so that's why probate is expensive, because it's requiring court time, and it's a larger task for an estate planning attorney to handle. If there's no will, there will be a distribution of someone's estate, but it'll go according to the mechanism that we have here in California. So if someone was a single parent and had 3 children, if they passed away without a will and without a trust, the property would eventually be distributed to the 3 children equally. It would be subject to the probate process, though, that we have here. All right, next slide. And in that scenario, if someone passed away without a will, without a trust, the court would indicate who would be the proper personal representative to handle that probate, let's say. So it would first be a surviving spouse or domestic partner, and then if there was no one in that role, it would be the children. If, once again, if someone had 3 kids, all of them would have the chance to go to court and decide who would be the best person to complete those probate tasks. So once again, it involves time, people sometimes lawyering up because they, in a well-intentioned manner, believe that they are the best choice. But if you indicate your desires clearly in a properly notarized document or a witness document with a will, you can indicate your choice as to who would be most appropriate. And this is just another chart that shows who would be appointed. So once again, you know, a single person has children. One of the kids, would, as long as they're adult children, would be appointed to represent the estate and make a distribution and do all of the tasks needed to go through a probate process. So once again, we want to avoid this because that may not be what you would like. Much better to indicate who you trust to carry out that role one day. So this illustrates some of the things that a personal representative or an executor under a will need to do. So, and this is why it costs money to go through this process. So they'll first file a petition for probate. They will thereafter have to publish a notice of petition to administer the estate. They will mail notices to various people, the natural heirs. They may need to file a bond with the court. They will have a hearing date on the petition for probate. They will need to prepare an inventory and appraisal of the assets, and they have to send it to the probate referee for evaluation and file that with the court. They will give notices to all the known creditors. They will pay the bills and debts of the estate and have to file the final tax return. Keep in mind that even with a trust administration, yes, the successor trustee will need to, you know, pay debts owed by the person who passed away, file the last tax return, but they don't need to file that in court and make appearances in court. Anyway, back to going through the probate process, that executor or personal representative will need to file an accounting and final petition for the final distribution, mail notice to interested people, set a hearing date and appear at that hearing, and then finally distribute assets and get a final declaration for final discharge. So there are a lot of administrative steps here. When you file things in court, it is expensive. There's a filing fee. It's often several hundreds of dollars. So it's a big chunk of change if you go through the probate process. Next slide. This illustrates the statutory fees that we have here in California. So let's go back to that example of a home, which is the only assets that someone owns, and it's $500,000. The fees here are going to be $13,000 to the appointed personal representative, but also $13,000 to the attorney who is helping the personal representative or executor with the probate process. So $26,000 will be coming out of that estate to pay those individuals. Okay, so it's relatively significant. If you have $1 million home, and keep in mind that this is the gross value of the estate. Let's say you have $1 million home and there's a lien against it, a loan against it for $800,000. The fee will still be, if you go across the page, $23,000 for the personal representative and $23,000 for the attorney who is assisting with the probate process. Okay, so keep in mind that the court only looks at the gross value of the estate when calculating these statutory fees. And next slide. All right. So let's go through this example, which illustrates why we want to avoid probate once again. So let's say we have that $1 million house, and that's the main asset. And we have a loan against the house of $300,000. So the net value of the estate is $700,000. The cost of some administrative tasks is $20,000. So staging a house, things like that to get it ready for sale. So we have a balance on the left of $680,000 to be distributed. If we go to the right, the probate side, we have that same fair market value of the home of $1 million and a loan against it of $300,000. So we have a net value of $700,000 ready to be distributed. When we subtract that cost of administration, we're down to $680. But because the fair market value of the estate at the time of death is $1 million, that $23,000 will be distributed to the person representative and to his or her attorney. So that will remove $46,000 from the distributable balance. And this does not include any extraordinary fees to the attorney or to the person representative, filing fees, tax prep fees. So once again, it helps to preserve an estate to avoid probate if you exceed that threshold amount. And next slide. So we're going to do a little question scenario here. So we have Pamela who died and left the following assets. So she had a house worth $300,000 and it was titled Pamela, trustee of the Pamela Trust, dated Christmas of 2007. We have 2 retirement accounts that total $145,000 and she indicated Ben as a beneficiary there. She has a life insurance policy of $70,000 and she indicated that her mother, Stella, was a beneficiary. Pamela was diligent and took the time to indicate a younger beneficiary. So she chose her brother, Leo. And unfortunately, her mother died, predeceased Pamela by 2 years. And then Pamela also has a bank account or bank accounts, and she's indicated her boyfriend, Tommy, as a beneficiary there. So in this scenario, do we think there would be a probate here? Okay, next slide. Pamela did a great job to help her family or help her loved ones avoid probate because she clearly had a house and titled that into her trust, which means that she created a trust at some point. She had 2 retirement accounts and had a beneficiary who was alive at the time of her death. So there's no probate with respect to her retirement accounts. Likewise, with her life insurance policy, she had a beneficiary who was living at the time of her death. So there was no probate there. And then with her checking and savings account, it wouldn't have kicked her into that amount that exceeds that probate threshold, but she even took the time to put a beneficiary down on those accounts, even though the accounts were only $2,000. So Pamela helped her family avoid probate. All right, so let's go to the next slide. Here we have Alex, and let's see if Alex's estate needs to go through the probate process. So Alex had a home with similar value, and it was titled Alex, an Unmarried Man. He had 2 retirement accounts and never got around to indicating a beneficiary on those forms when he set up those accounts. He had a life insurance policy of $70,000. He placed his father, Sean, as a beneficiary, but he did not take the time to name a second or contingent beneficiary on that policy. Unfortunately, his father, Sean, passed away prior to Alex's death, and Alex never got around to changing that beneficiary designation on that life insurance policy. And then he indicated a beneficiary on his checking and savings account. It's a relatively small amount in that account, but it was my girlfriend and a rather ambiguous beneficiary designation. So in Alex's situation, upon his passing, was there a probate proceeding that had to go underway here? You're right, Barbara. Yes. So there is a probate here because he did not have a trust, as evidenced by the fact that he didn't ever put anything into the trust. He owned his home personally, not as trustee of his trust. So there would be a probate just with the house here. He never indicated a beneficiary on his retirement accounts, nor did he do so with respect to a contingent beneficiary on his life insurance policy. And then with his bank accounts, he was ambiguous, and it would be very difficult to determine who is a specific beneficiary on those accounts. So there would be $517,000 that would need to go through that probate process. Okay, so about $26,000 would come out of this estate upon his passing. All right, next slide. So we're going to look briefly at a transfer on death deed. It can work for a single family home. So if someone is fortunate enough to have a building that's more than a fourplex, it won't work, but it can work for a condo or a single family home. We have some clients who live in rural areas, and if they have over 40 acres of land, it certainly won't work with that. So this is a deed where you can indicate beneficiaries by name, and it needs to be recorded within 60 days of the execution of this deed. If you ever change your mind, you need to clearly revoke this deed. The limitations here are that typically with estate planning, so let's say I have a client and it's a mom and she has 2 adult kids, she might provide in her trust that she wants everything to go equally to her 2 kids. If one of her kids passed away, she would want that child's 50% share to be held in trust for that child's children. So her grandchildren from that deceased child of hers, and it would be held in trust until, let's say, age 25 to be used for the grandkids' health, education, support, because the parent had passed. And then that 50%, whatever was remaining, would be doled out to those grandchildren from the deceased child at age 25. Well, with this deed, if that same parent put the 2 kids down as a beneficiary and one of those kids passed away, a home, the piece of real property here, would go to the surviving child. 100% would go to the living child of that parent. So sometimes that is not what a client wants. If someone has 1 child, they might want to put that 1 child down as a beneficiary. That can sometimes work. And next slide. So here's an example of what the deed looks like. It's relatively simple to prepare. Note that it needs to be obviously notarized. So if you do prepare this deed or have someone prepare it for you, you need to wait to sign it in front of a notary. And then if you change your mind with respect to the beneficiary here, you need to specifically revoke it. It's very important. You wouldn't want to file it and then change your mind about what you want to have happen and forget to revoke it. Next slide. All right, so those are the different ways to avoid probate if you exceed $166,250. Now we're going to go into the other part of estate plan, which concerns what happens if we're incapacitated. What documents do we need to handle those situations? So I'm going to pass it on to Irene, who's going to present on this portion.
Thanks, Kendra, for guiding us through the jungle of wills and trust and probate. So now we'll talk about the other important documents that's part of our estate planning also, as Kendra briefly touched upon. One of them is durable power of attorney, POA for short, if you have heard of it before. And another one will be Advanced Healthcare Directive. And they have similarities, but also significant differences in the area of matters that they take care of. And again, they are important during our lifetime to take care of situations where we're still alive, but become incapacitated for one reason or another, either for short term or long term. And they will kind of lose value once we pass. So power of attorney and healthcare directive are important part of your estate planning, regardless of your age or your background and the makeup of your asset, because it really concerns our healthcare decisions, as well as who takes care of our finances, or just even having access to our bank accounts when we cannot personally do that. And it also allows us to just personalize our care when we're still alive and able. We can make those plans in case we become not available to take care of ourselves. And it also avoid expenses and potential conflict of conservatorship proceeding, which I will talk a little bit more later on. And it's basically a court proceeding that takes care of naming someone that will, access your bank accounts or carrying out your health wishes for you. And that person the court appoints might not be the person that you want. So there are different kinds of power of attorney documents. You can limit the powers that you grant to the agent that you name. It can either be a blanket authorization with all kinds of powers, or it could be limited powers if you only want access to bank accounts and filing tax return and paying your utility bills and things of that sort. You can name those, but maybe limit investment decisions or things concerning mortgage. So you can personalize it quite a bit. For both power of attorney and healthcare directive documents, there are considerations when it comes to picking an agent. It's similarly to the trust and will that Kendra talked about. It's prudent to name more than one potential agents. If the first choice person cannot act when the time comes, then there will be backup choice number 2 or even 3 that can really help you. And it's probably better for especially healthcare directive to choose agents that are closer to you physically, so that when there's a medical emergency, that person can be available. For advanced healthcare directive and power of attorney, because they take care of different areas of your life, people with different skill sets. And so you don't have to have the same agent that are on both documents. And it's also a document that you can feel free to amend as long as you're alive and able to do so. And there will be changes. Your agents might move to another state, or you want to name your children as your agent. They're still young right now, but when they grow older, they can they can act on that role pretty well. Then you can name them then. So it's a document that is also kind of growing with you as you go through life. So conservatorship is the court proceeding that I talked about, and it's the court, a judge that doesn't really know your circumstances, that will appoint someone according to the statutory chart, kind of examining closeness in relationship and appointing people that will help you make financial decisions and healthcare decisions. And it's more costly than you naming someone yourself too, because the court will supervise each action, and there will be quite amount of I would say inflexibility, and there are certain cut out procedure of how things are taken out and carried out. So if you remember from last year, the big news about Britney Spears' conservatorship, and finally she is able to get rid of it, and it was quite a conflict. So you want to be able to avoid that, and the cost that you pay to avoid that is quite small in comparison. And since you're just setting up these documents, that doesn't take much time nor money. So there are different other documents in the healthcare setting that would be appropriate for specific circumstances. You might have heard of it before, a post form, which is a pink slip that I will show in the next slide. And it's for older people with quite significant health issues to kind of name their wishes so that when the ambulance comes and there's a medical emergency, a medical worker have a easier time knowing this person's wishes. And there's also the DNR form, the do not resuscitate arrangements that people can make prior to a major procedure in the hospital. And there are also other end-of-life options. So some of them overlap with what Advanced Healthcare Directive talk about, and some of them are separate, but you can make references to these other documents and arrangements outside of Healthcare Directive. But they do have different arrangements for different circumstances. So this is the example of the post form. In some other states, it might be a slightly different name, but they govern the same purpose. And this is the DNR form. So far we talked about all the major documents that are part of your estate plan. And when you go to meet with attorney to start the process of setting up your estate plan. If you're married, it's good to go with your spouse, and so that you can kind of voice your concerns and your even disagreements to the attorney, and the process of talking about it together will help you really understand maybe the considerations that you haven't thought about on your own, and differences that you didn't know until you talk about it. And when you meet with the attorney, usually you receive a form where you provide personal and financial information, about who is in your family and who do you want to name as your agents, and the financial details. So there's it's easier for the attorney to know just what you own and what's the best strategy for you personally to kind of really avoid probate, and also there are some things that you might not even need. But yeah, it's good to provide as many information as possible about your personal and financial situation, and there will be quite a few back and forth processes, and you review different drafts of documents until you're satisfied. And when you sign, finally, you sign in the presence of a notary public, and some documents you sign in the presence of witnesses that are disinterested in your estate plan. And once you have your documents signed in the presence of notary or witness, they take effect then there. But then it doesn't mean that's the end of your estate planning. It's very, very important to actually fund your trust, and what that looks like for real properties. You actually execute a new grant deed, and you transfer the house from yourself as the person into the trust, which you fully control, and you have to get that grant deed recorded at the county recorder's office. And so that's one example. And there are other assets where you would fund into your trust in different manner. And that's something really important to talk to the attorney when you are done with the signing process. And after that, it's also highly recommended that you revisit your estate plan every 3 years, 5 years, and some documents like power of attorney and advanced healthcare directive, some banks and institutions might require documents that are newer than 5 years old. Then it's a good idea to execute new versions, especially if you have changes. So yeah, update your documents accordingly. And these are just examples of famous people that unfortunately didn't do the work of reviewing their estate plan or setting up an estate plan. And so for Barry White, he was separated from his second wife, and he lived with this girlfriend for a really long time. But because he didn't update his documents after he passed, the girlfriend didn't have any right to claim anything. The wife that separated from him long ago took it all. So and other celebrities here have similar kind of unfortunate situation, but if only they had updated their documents, it could have been avoided. So we are all part of HERA, and this is a brief introduction of our organization. We're one of the few nonprofits in California that provide estate planning services directly to clients. And if you have any questions, as Leah has put in the chat in the beginning, there is our phone number here and our website. And you can also send your inquiries to this email address here. And so now we saw there's some questions in the chat that we haven't addressed. We touched upon the questions related to probate in the course of our presentation already, but if you still have follow-up questions, you can feel free to raise that. And I will hand it over to Kendra to review some of the questions and answer them.
Certainly, thank you so much, Irene. Yes, I had a couple questions about probate. Some of them were before I really kind of went into it a little bit more deeply as far as all the processes that a personal representative would need to go through. But keep in mind, it typically takes at least a year and a day. People have to appear, although nowadays, sometimes it's Zoom appearances. People typically hire an attorney, which is expensive. That attorney is going to receive that statutory fee and perhaps could receive extraordinary fees if there's any kind of conflict or chaos. So once again, there are a lot of steps to the probate process. Administering a trust is quite simple. While the beneficiaries of a trust will, at a person's death, receive a copy of it, you don't have to jump through the hoops and publish something in the paper and do all of that. In a similar vein, while the successor or the trustee of a trust will need to pay the debts of a decedent, they don't need to send out formal notices. They will just look at the bills that are coming in and promptly pay those entities and indicate that the certain person has passed away, and to just discontinue credit cards, etc. So it's a much more streamlined process administering a trust as compared to probating a will. Let's see. Someone asked about whether or not a retirement account would be calculated in the $166,250. So as long as a retirement account has a beneficiary on it, that's one of the tools to avoid probate. That will not be counted in that amount. That amount is assets that have to go through the probate process. So as long as you have a living beneficiary on an account, or have assets in a trust, or even the proper kind of deed to indicate a beneficiary, those are not counted in what would have to go through the probate process. Sometimes we have clients who create a trust, put their home in a trust, put beneficiaries as needed, and then they had two little accounts where they didn't indicate beneficiaries, and they didn't get around to placing those accounts, retitling those accounts to their trust. Well, if those accounts add up to $50,000, their family will not need to go through the big probate process. Their family can typically create small estate affidavits and handle that. It's much easier if the decedent, had placed those accounts, even though they're small, in the trust. But if they didn't do so, at least the family will not typically have to hire an attorney and go through the whole probate process. So once again, retirement accounts would not be counted as long as there was a living beneficiary on those assets. Let's see here. We have Hera's website. Another question is for someone who already has a trust, if they amend their trust or do what's called an amendment in the entirety and restatement of trust, basically create almost a new document, they do not need to change their deed as long as the deed was already in that trust. When we amend a trust, we never change the name of the trust. We don't even change the date of the original execution or signing of that trust. So any deed, any accounts that were put into the trust will still be in the trust, even though intentions have changed and have been evidenced in a future writing. That's the good news. Once you put things in the trust, you're assured at least that they will avoid probate. The most important thing to do as you are reviewing documents and making sure that they still express your desires as to, what would be an appropriate guardian, how you want assets distributed. Please make sure that you are also reviewing your assets. Did a beneficiary indicated on a life insurance policy or your retirement account pass away? And is there no listed beneficiary there anymore? That's usually what we find prompts a probate. People might have originally put assets in the trust, they sell a home, they purchase a new home in their own name and never have the title company put it into their trust. They just forget about it, they pass away, there would be a probate. So please always review your asset list and make sure that the appropriate things are in the trust. Someone asked about spouses. So if you have a bank account, you're not going to put it in the trust. If your spouse is, you might want to own that together with your spouse as a joint tenant. There are certain benefits of doing so, frankly, between a married couple. Short of that, you would want to indicate that the spouse is a beneficiary. If that was not done, and if someone's passed away, a spouse can do a spousal petition. That is something that they would file in court. It's something that our office doesn't do, but there would be a mechanism for a spouse to claim a right in an account. I would first start off with going to that institution and finding out specifically what they need. If it's a relatively small amount, and if there are no kids, it might be a relatively simple form that the bank has. So always start there. Financial institutions are different with respect to what they will accept and what kind of documentation they need when it comes to distributing assets at someone's passing. Good question. Should an account with a beneficiary also be in a trust? The beneficiary designation would trump the trust. So it's best not to have any conflict as far as distribution at death goes. So if you have an account and you're going to put a beneficiary on it, that's fine. Put a contingent one, or alternatively, remove the beneficiaries, retitle that account to a trust, to your trust, and if you should pass away, that account will be included in the trust assets and will be distributed according to the terms of the trust. So it is best to pick one of those mechanisms for distributing that asset upon someone's passing. If there is no trust or no will, does the firstborn have rights to be the executive, or I think this person meant executor? Not necessarily. If someone passes away and the court needs to choose a personal representative, it might have to do with, geographic location or someone's character, someone's skill set. So the kids will perhaps duke it out to prove that they are the one, that a particular child is the one to be the best appointee as far as a personal representative goes. Once again, much easier to indicate who you think that person should be in your properly executed estate planning documents.
I see that Usha Gupta has a hand raised, so I'm going to go ahead and unmute.
Okay. My question is how often you can change your estate planning?
There's no limit and there's no restriction as to how often you can change your
How
estate
long?
planning.
how long it's good if we don't change? How long-
It's really, it's good for a long time, frankly. As long as it clearly meets your intentions and people are alive and those people still have capacity, it should be effective, until you pass away. With the exception of sometimes banks like a durable power of attorney, which was executed in the last 10 years. So I think it's a good idea when people come in, let's say, and they want to amend their trust, if they have an old durable power of attorney, let's say it was executed in 2004, we typically redo their durable power of attorney because a bank will sometimes see an old power of attorney and they don't like the fact that it's 15 years old. So that would be the exception.
But for changing or reviewing, there's no charge every time?
Oh, there is a charge. Whenever an attorney is going to prepare new documents, they will typically charge for creating these new documents. Absolutely. So I recommend that people really get their thoughts together, make sure it's not a change on a whim.
We already have one, but I was just wondering, just checking. for my
Okay,
knowledge.
good.
Yeah.
I'm glad you have a
Sure.
trust.
How often it need to review or, something like that.
Yeah, I mean, we recommend looking at the trust and documents every 2 to 3 years. I think that's typically a good
Good.
rule to go by.
Thank you. This was very
Welcome.
informative. Thank you very much.
Great, thanks for coming.
Sure.
And so how much does it cost to set up a trust? Attorneys might charge hourly, or they may charge a fixed fee for an individual trust package or a marital trust package, which includes the documents that are important when people pass away, as well as documents that are important when clients are alive, but let's say incapacitated. So it could be hourly or fixed fee. We here at HERA charge a fixed fee, and our fees depend on your income level. So whatever your income was last year, we will put that on a schedule and it will indicate the fee involved. We charge on a sliding scale. Our fees are less than you will find in private practice typically, but we really can't give you an idea of what a specific fee would be. You would need to call us or email our inquiry line and have one of our admin people set you up with an attorney, or at least let the admin person know what your income level is, and they can give you an idea of what the fee would be. Services like LegalZoom or FreeWill. If you know what you are doing, and it's a very simple, let's say, individual trust or will, let's say you're under $166,000 as far as probate assets go. And if you, let's say, in the event of creating a trust through one of those mechanisms, if you are absolutely sure that you are titling your property to the trust that you created, which means if you're a homeowner creating a new grant deed where you are conveying your interest individually to your trust, at times that can be okay, but I'm not really going to comment on the quality of their documents. It's just really a case-by-case basis. I will say that creating your own durable power of attorney or healthcare directive can be fine. There is a California statutory power of attorney that you can pull off of the internet, which is brief, but can fill the bill. And then for those of you who are with Kaiser or Sutter, you can, I believe, go online or obtain from your physician a healthcare directive form and complete that on your own, fill out your intentions, indicate your agent, and make sure to sign that either with the notary or in front of two disinterested people. Those are people not indicated in that document. And then take that back to your physician or medical team so that they scan it into their system so that they will always have that good contact info of your agents. So that can be a way to obtain those documents. Great, thank you for posting that link to a healthcare directive. Someone just posted in the chat a link to the Kaiser healthcare directive, which is quite comprehensive, quite good. It really prompts a lot of thinking about medical issues. You're welcome. Anything else?
Okay, well, it seems like we don't have any more questions, but of course, if a question comes up after the training, you are very welcome to contact Hera directly, and I'll be sending links to contact them, and also the link to this recording and resources after the event. Be sure to complete your evaluation. You'll be receiving that today in email. I want to thank the presenters today. Thank you so much, Kendra, for all of your knowledge and experience. And also Irene, thank you so much for presenting today.